just this first part. And we have, like I said, just a few more things to wrap up. This last little section, or next to last little section, I should say, this is our alternative land conveyance, alternative methods to convey. And these, you know, the big thing to be aware of these is if one of these ever come up, if you ever get the opportunity to brokerage one of these, the name of this game is have your client call their attorney. Because as we're going to learn in just a minute, we don't have pre-printed forms for these scenarios that we're getting ready to talk about. We don't have, so we got to get an attorney involved anyway to do the forms, but just having them be aware. So really what we're doing is just kind of introducing you guys to these. So, you know, when your little red flag goes up, you know that that's your key to get an attorney involved to assist in the transaction. So the first alternative land conveyance method that we have is something called an installment land contract. And with an installment land contract, the buyer is paying the seller. The buyer is paying the seller the purchase price, but they're not doing it in one lump sum. They're doing it in installments. So we agree, I'm going to pay you X amount per month for however many months until this thing is paid off. The difference between an installment land contract and seller financing is when the deed changes hands. So in seller financing, the buyer gets the deed at closing. In an installment land contract, the buyer does not get the deed until the very last payment is made. So the big benefit for the seller with these is that they keep that legal title. We'll talk about in just a second what happens if the buyer defaults. So the seller keeps that legal title, the deed stays in their name. The buyer gets equitable title, which means they have the right to live there. They have the right to occupy, to use the land, possess the property. When you guys buy a home and you use a lender and you have a mortgage, you have equitable title. The lender lets you live there. Right. And that's kind of the same thing that we're doing here. The seller lets you live there. The buyer live there. They're just making those payments. The official terms, the vendor, the givor of the installment land contract is the seller. So the vendee is the buyer, the receivee of the installment land contract. And what makes this unique, the buyer's buying and the seller's selling, but what makes this unique is, in addition to that, the seller is acting as the financing device. So there is no bank, there is no lender involved. Because of this third piece, because the seller is the financing device, we cannot use our standard offer to purchase and contract because we don't have verbiage in there for the seller to be that financing device. So that's why if one of these comes up, we just don't have a pre-printed form. I don't know how often this happens. I've never had one, but if one of these comes up, we need to get an attorney involved anyway to draft up a form. There are rules that revolve around these installment land contracts, which is another good reason to get an attorney involved. Make sure we're following the rules and laws. Chapter 47H is our contracts for deed. And there's a couple things that they give us. Again, the attorney's going to be aware of these. The seller has to record the installment land contract within 5 business days of execution. This prevents the shady seller from selling it out from underneath the buyer. So let's say we have a 10-year agreement, right? I'm going to pay you once a month, every month for the next 10 years. Because it's on record, the seller can't sell it to anybody else, right? It's going to be recorded. And if the buyer defaults, if the buyer misses a payment, then the seller, this chapter 47H says the seller has to give them up to 30 days to cure the default. So if the payment's due, let's say on the 1st, and they don't make the payment, the seller can't kick them out on the 2nd. They got to give them 30 days to cure that default. In the event of this, to cure the default, the seller could call for the whole note due, kind of like the banks, right? In a foreclosure situation, they could say, you can make all this go away if you just owe me everything that, just pay me everything that you owe me. But they got to give them that 30 days. If after 30 days they haven't gotten it, then they can start the summary ejectment. They can start the proceedings to get them out. Pluses and minuses for everything. The big advantage for the buyer, this could be an alternative means of financing. Maybe a buyer that's hard to get a loan, maybe they just came across a rough patch in their life. Maybe they encounter some serious medical bills, for example, and they just can't get approval for from a lender. So this might be an alternative means for them. There's usually lower down payments and lower closing costs. And because the buyer is living there, they're paying taxes and homeowners insurance and all that other good stuff, there could be some tax advantages to them. The biggest disadvantage to the buyers if they default. And we're going to see in just a second that there's probably the biggest advantage to the seller is in the event of the buyer's default. If the buyer defaults, the seller can have them evicted, right? They can't do it within 30 days, 31 days, the seller can have an evicted, summary ejectment, but they're going to lose any previous money that they already paid. So in other words, the seller doesn't have to reimburse them. So what they've already paid is, keep in mind, if the buyer does default and they can't come up with it, the seller still has the legal title. So they get that person out, keep the money they already earned, they already received, and then they can turn around and re-rent it or, try to sell it, however they want to proceed. Keeping in mind too, that the deed doesn't change hands until the last payment is made. And when that last payment is made, the buyer is encouraged to have an attorney do a title search, just in case, what if something came up from the time we went to closing to that last payment? What if the seller put something on that title? So hopefully the buyer will be encouraged to have that title search again, right before that last payment is made, right before the deed changes hands, so they know what they're getting. But because of that, there's going to be added legal fees. Again, we just, at a bare minimum, we have to have an attorney draft that agreement up, draft that contract up. So there's going to be some added legal fees. Advantages and disadvantages for the seller. They still have the deed, so they too may be able to benefit from some income tax advantages. The seller is going to keep the legal title until that last payment is made. In the event of the buyer default, the seller keeps all money that they've already received. But for the seller, this could be an easy way to sell a hard to sell property. I think of, for example, maybe a property that just needs lots and lots and lots of repairs and updates and some renovations, and it takes a special buyer, it takes a special somebody to purchase that home. So maybe we can work a deal out, while you're living here, if you want to fix this or fix that, right? They could kind of make that arrangement. But it could be a way for a seller to sell a hard to sell property. Probably the biggest disadvantage for the seller is that they're not getting it in one lump sum. So if the seller needs all that money today, this may not be an option for them. Now, if they can stretch it out over 5 years, 10 years, 18 years, whatever we agree to, then that could work for them. But they're getting a low down payment. They're paid in small payments. And then again, there could be time and cost going to court, summary ejectment, legal fees, that kind of thing, if the buyer defaults. Questions on an installment land contract? Let me ask you guys this. Let's say you have a listing. You're the listing agent, and an offer comes in from a buyer that wants to do an installment land contract. Do you have to present that to your seller?
Yes.
Yes. Why? Because we present
all offers.
All offers. So an offer to do an installment land contract is an offer. So as much as you don't want, you may not want to do, it's not really up to us, is it? So an offer comes in to do this. If your seller has, we can give them the basics, the gist of it, pretty much what we know, right? And if they have further questions, we need to have them talk to their attorney before they respond to that offer. Another alternative land conveyance we have is the option to purchase. We briefly mentioned this, gosh, whenever we started, what, 3 weeks ago? It seems like so long ago, doesn't it? And we said the option to purchase. This is our only example of a unilateral contract. So in real estate, the majority of what we do is a bilateral. Bilateral means two sides have to perform, two sides have duties and obligations. The option to purchase is our unilateral contract, which means only one side has to perform. So with an option to purchase, the buyer has not promised to buy. The buyer has simply requested the option to decide if they want to buy. The only promise made in an option to purchase is a promise from the seller. And the seller is promising the buyer that they won't sell to anybody else during this option period. At the end of the option period, the buyer either decides to buy or they don't. So the buyer is binding the owner. They cannot sell their property for X amount of time. And what it does is it gives the potential buyer the legal right to either accept or not accept the auctioneer's offer. We're going to agree to all the terms up front. Basically, what we're saying is at the end of the option period, if I decide to buy, then these are the terms that I'm going to buy. We know the purchase price and the dates and the deposits, all that is agreed to up front. Another thing that's very unique about an option to purchase, we don't just have one form of consideration like our sales contract. Our sales contract, the only consideration is the purchase price. But in an option, there's an additional form of consideration, which is an option fee. The question I always get is, why in the world would a seller agree to not sell their home for 2 weeks, 2 months, 2 years? Why would they agree to do this? And my answer is, that's right, Ronnie, money talks, doesn't it? This option fee is usually pretty healthy. This was like big due diligence before we knew what big due diligence was, right? This is usually pretty healthy money. So you write me a check and say, Julie, don't sell your house to anybody for, 2 weeks. Here's, I don't know, $5,000. I'm going to say, all right, it's a healthy fee. Now, if the buyer buys at the end of the option, that option fee will be credited back to them. If they don't buy, then the seller will keep that. They've paid for that option. Yeah.
And this is really not that uncommon in commercial transactions.
Commercial, I bet not. I bet this happens a lot in commercial. Because in commercial, you have the, what's that period called that they're exploring it? The
discovery.
Discovery period. Thank you. It was right there for both of us. I can see it. Yeah, the discovery period. So they could kind of incorporate all that, roll all of that into this option time as well.
And for a good example is, if I need a warehouse and I find something less than ideal, I still need a space. So I'll lock that down while I'm looking for the ideal warehouse.
There you go.
And in that time period, I've got a fallback.
There you go. Ronnie, based on your experience, the example I usually give, so let's see how right on this is. The example I usually give is somebody sent to, let's say you work for Corporate USA and they want to open a warehouse or a plant, Wilmington or something. So they send you to Wilmington, you find 2 or 3 places that could be a good fit. So you enter into 2 or 3 different options to decide which one would be the best for Corporate USA. And at the end, you're going to buy one and not buy the other.
Especially if the final decision is not up to me. If I'm
there you go.
And need to present 3 options to the actual person, then that's a great way to lock it down. And
so I could come back from Wilmington and say, I found these 3 properties. Which one do you? Yeah. So, okay, good. I'm glad I've been on point all these years. With an option, the optionee does not have title or legal interest in the property. They don't own it. They can't possess it. They can't rent it, right? They are just exploring their option. They're deciding if they want to buy it or not. Again, if the optionee does decide to purchase, the terms have already been spelled out. So, here's an option for 2 months. And at the end of 2 months, if I decide to buy, this is the purchase price. This is the only thing, you know, we're going to pay the option fee up front, and then anything else is going to hang tight until the end of that 2 months if I decide to purchase and move forward. The only promise made, the only right that the auctioneer has is that they can't sell it to anybody else during that time. So if we enter into that 2-month option, you know, I'm not living there, I'm not occupying, I'm not possessing, I'm not profiting, I'm just exploring my option. And the seller can't sell for 2 months. The seller can't withdraw their offer to sell. So let's say I go to these warehouses and I bring my general contractor with me, and then we find a whole bunch of problems. Can I ask to reduce the price? Can I ask for repairs? Can I ask? Sure. Is the seller under any obligation to re-enter into negotiations with me?
None whatsoever.
Absolutely not.
He's got his option check already in the bank.
He's got his option. He went out for a fancy dinner last night, right? He's out spending that money and celebrating. So, you know, all terms are negotiable, of course. And you know, this sounds awfully familiar to our due diligence period, right? The seller's under no obligation. We can always ask. The worst they can say is no. What the seller can't say is, I'm terminating because you asked, right? They cannot withdraw that offer to sell. That's an agreed upon price. We can try to renegotiate, but the seller's under no obligation to engage in such negotiations.
But also using that general contractor example, if it is something in the discovery period that is a material defect, it may be well worth the seller to negotiate as compared, especially if they wasn't aware of that material defect.
Exactly.
Of it, they may be willing to cut the price.
I agree. Because that it's not going to go away, is it? So it's going to come up again with the next buyer and buyer after that. So I agree. Sometimes I think in residential too, I think sometimes it's best for the seller to do it. Just understanding they're under no obligation. I think in the residential world, the best example for that is high radon levels. You know, I think it's just in the seller's best interest to put in a mitigation system because radon's not going to go away.
And make sure the mitigation system's working.
Yeah, and have it checked again, right?
Remember, I had a 10.
You had, that's right. That's high. Goodness, that's high. Like we said, I don't have a pre-printed form. Our offer to purchase and contract just doesn't have the verbiage for this. Remember, the offer to purchase and contract, the seller still agreed to sell, but the second piece of that is the buyers agreed to buy. So in the option, the buyers made no such promise yet. So again, we just got to get an attorney involved. And specifically with the option, the statute of frauds and the Connor Act kick in. The statute of frauds says that it's got to be signed and in writing, so it's enforceable. Connor Act says it needs to be recorded to be enforceable. And again, the reason we, or the attorney, I should say, wants to put this on record is if I'm locked down for 2 months, then I shouldn't try to be shady and sell it out from underneath you, right? So this helps keep the seller honest. And if anybody else wants to purchase, the closing attorney is going to find this. So again, let's see if this works. Yay. With the option to purchase, sometimes it does and sometimes it doesn't. Then we just need to call our attorney or have your clients call their attorney, I should say. Questions on the option? The last alternative land conveyance that we have is called a preemptive right. And I got a couple different types of preemptive rights that we're going to talk about. But the big picture of the preemptive right, it gives a person the contractual first right to purchase. So we're in a contractual agreement. You may not want to sell yet. I may not want to buy yet. But when you do decide to sell or I do decide to buy, we're legally bound to come to each other first. And that's what we're doing with a preemptive right. A couple different types of preemptive rights. We've got a right of first refusal. This one gives the owner, the contracting party, the opportunity to match a bona fide offer. So with the right of the first refusal, the owner has received an offer. They have an offer from another buyer in their hand. But because the preemptive right buyer has this contractual obligation, the owner has to go to that person first before they can respond to the offer in their hand. They got to give them that right. If you guys ever get an opportunity to, once you start working with buyers, and you ever get an opportunity to show property in Old Salem houses have right of first refusal. It's got to be approved by Old Salem Inc. And that verbiage will be for you in the agent only remarks. You'll know before you show it, so you can get your buyers some longer due diligence, right? So we can, hash this out, that kind of thing.
Yeah, I had one of these on a little horse farm that I bought in 2002. And I haven't ridden a horse since I was a kid, but I like acreage. And the adjacent property owner, I had 23 acres, he had 600, but he wanted my 23 to go along, and we entered into a contract. If I ever got ready to sell, he had first right of refusal, and that's
Nice.
who bought it at the end.
Nice. I think where we see this, and that's a really good example, neighboring lots. I like that one. I think where we may see this a lot too is with leases. So, maybe you have a tenant that's been there for 12 years and they really like it. They're taking good care of it, right? And they may go to the landlord and say, look, if you ever decide to sell in the future, let's enter into this.
And also you can get into a familiar, a family situation of, well, it was the house I grew up in, might be the house I want to retire
There you
in.
go.
If you ever want to
There you
sell that, enter into a first right of refusal that way.
There you go. That's a good one.
It's really a safety net. Most of the time, there's no money exchanges hands up front. It's just an agreement.
Right. The other one is the right of first opportunity to purchase. Again, this one gives the contracting party the first opportunity to purchase at a price to be determined. So the big difference in the two, I'm going to go back for 1 second. Right of first refusal and right of first opportunity to purchase. The big difference in the two is the right of first refusal. You have an offer in your hand. Both, again, maybe I don't want to buy yet. Maybe you don't want to sell yet. But in the future, if you decide, right of first refusal says when you get an offer, come see me. This one says whenever you decide to sell, then you come see me and we'll decide on price, that kind of thing. Attorneys are involved. I don't have pre-printed forms for these. So whatever the parties agree to, an attorney can draft something up. Questions on our alternative land conveyances?
Pretty straightforward.
Okay. I kind of sort of, well, my husband kind of sort of had one of these with our neighbor when we lived in the condo. He went down to his car. We were on the second story, and he went down to his car to get something. And he came back up and he said, I think I just sold the condo. I said, well, I need you to say more. And he said the neighbor met him on the stairs and said, hey man, you guys ever want to sell? You let me know. And my husband was like, all right. And I was like, but that was it. That was as far as it went. Right. So, but there's just kind of that verbal, obviously that's not going to go far. That's not going to stand up, but it was good to know that somebody had an interest.
I used to have an employee out in, well, he actually had a home in Phoenix and one in Memphis, but he would come home, and he did this half a dozen times that he was in my employ, and tells me, oh, I sold the house today. But it wasn't for sale. Well, somebody offered me enough money. And he did it at least a half a dozen times.
He was good.
Yeah. And they would move, and 6 months later he'd come home, hey, sold the house.
Isn't that something? There was a lady in High Point. She was we unfortunately lost her a little over a year ago. But she was known as the realtor's realtor. So she was the agent's agent, and it didn't matter if you were with her firm or not. She was going to do what she had to do to help you out. And I mean, goodness, she'd been in it for 30 some years. She was a top producer for 28 of those, just a very well-known name around here. And I remember the story she told one day about she was working with buyers, and they were describing what they wanted. And what they wanted was the house that she owned, her and her husband currently lived in. So she showed up. She said her husband was, at home one evening in his recliner, with his slippers in his newspaper, right? And she came charging in the front door with her buyer saying, I got somebody interested in the house. And he was like, she sold it. She sold it. He was like, where are we gonna live? And she was like, you know, we'll figure that out. All right, the last little section, we need to talk about some licensee status education issues. You guys are going to see this. I think you talk about this in your other post licensing as well. You're going to see this in most of your CE classes. They're just going to kind of constantly remind you about paying that renewal fee, you know, having that active license. And guys, the reason for that is because every single year the Port Commission goes through this. Every single year on, you know, July 1st, their phone is blowing up and people, panicked agents are saying, I didn't pay my fee. What do I do? You know, so until all of us across the state can get this, then we just got to keep reviewing it and going over it and CE, that kind of thing. So let's talk first about having an active license for a full broker. I'll bring the provisional broker in for just a second. But as the full broker, what you need for an active license is you need to do your education, your CE each year, which I will talk about, and you need to pay the renewal fee. When you pay the renewal fee each year, your license is current. And a current license can be either active or inactive. The license is current because you paid the fee. When you guys see current, I would actually like you to see the word currency. A current license has everything to do with paying the fee. It has nothing to do with education. So if you pay the fee, your license is active. If you don't pay the fee, your license is expired. So I said inactive, I think. If you pay the fee, let me say that again, please. If you pay the fee, your license is current. If you don't pay the fee, your license is expired. Then a current license, you need to take it a step further. If you do your CE, that current license is active. If you don't do your CE, that current license is inactive. Everybody with me? So our license statuses are either current or expired. A current license can be active or inactive. The second piece for provisional brokers, as you guys know, you have to take it even a third step further, don't you? So as a provisional broker, you got to be affiliated with a broker in charge. You got to be affiliated with a firm. And you need to do your post licensing. We'll talk about that a little bit in just a second too. Questions on that, current or expired? This is the call the commission gets every year. You're telling me my license is expired? Yes. Why? Because you didn't pay that fee by 11:59 p.m. on June 30th. The renewal period, well, first off, the Real Estate Commission works on a physical year. They do not work on a calendar year. And the commission's physical year is July 1st to June 30th. And our renewal period every single year is May 15th to June 30th. May 15th to June 30th is our window to pay that renewal fee. Do you have a question? No. Okay.
Not yet.
Okay. I just saw you on mute, so I don't want to make sure.
Well, it's always embarrassing when I start talking and I'm muted.
Better than talking and being unmuted, right? In some cases. As we said, a current license can also be inactive. Why is it inactive? You paid the fee, but maybe it's inactive because you didn't do CE. Maybe you're a provisional broker without a BIC. Maybe you don't do your post licensing in time, or maybe by choice. I always encourage licensees, if you think you're done with real estate, you know, life brings us to forks in the roads on a regular basis, right? So you come to a fork in the road and you have a decision to continue with real estate or not, and you choose the road of not. I always encourage licensees at a minimum to pay that fee every year. Send in that $45 each and every single year. And I'll tell you why in just a second. So by choice, how we reinstate an inactive license, this is just more FYI. If you are inactive with no CE deficiency, so in other words, you've been paying the fee and you've been doing your CE. All you got to do is submit the license application form, activation form. If you're inactive for less than 2 years and you have a CE deficiency, less than 2 years with a CE deficiency, then they're going to make you get caught up on CE. They're going to make you do this year's update and elective, and then they're going to make you do another elective or two, depending on how far behind you are. If you're inactive for 2 or more years with a CE deficiency, you're going to do this year's current CE, and then you're going to come back and do 2 of the 3 post licensing. And you can choose, you can do 301, 302, 303, you know, whichever the 2 that you want to do. But you guys will learn, laws and rules change so frequently. And the thinking here is that if you've missed more than 2 years without a CE, you've missed a lot. So we got to get you up to date on your CE. And we also need to get you caught up, maybe, like we said, in a couple post-licensing classes.
And Deborah, isn't this your second go round on having your license?
Is this the category you fall under, this third one here?
No, because I did mine in 2006 and I never activated them. So
No.
then right after I had received it, the post licensing became a requirement. When I was doing it originally, it was not. So I had to go all the way back and do pre-licensing and everything again. But it's interesting, Julie, because when I was doing the Learn Test Pass, I went through this section, and my current status when I go to renew says my license is renewed. But I did my state test in early April, did the application and finalized that, you know, paid for the license after I passed the state in May. But if I'm reading on Learn Test Pass, it says I should have had to renew again by June 30, but I didn't.
When in May?
Early May.
Yeah, you should have had to renew, because that
Ah,
renewal
so
period
while we were
doesn't start until May
talking-
15th. I
I
mean, I
know,
wouldn't call the
we're-
commission and tell them, but you know.
Well, I mean, we're talking and I go into licensee, to me, I'm logged in, and I go renew your license, and it says license number has already renewed. Click here to return to the main menu, and there's nothing. Because Lane
Weird.
said, guys, don't forget, and I went
Yeah,
in,
oh yeah.
and I'm like, Lane, it says I'm good.
That's what they always tell us. I mean, we're only as good as the information we get, right? And that's what the commission always tells us, that if you get your license on May 14th, you have to renew on May 15th. Now, if you get your license during the renewal period, you're in. It sounds to me like you slipped through the cracks. I'll be really honest here.
I might have to look at my my license card or something, because look at where do I see my card?
Yeah, it sounds to me, because I mean, they send me, well, they send all of us, not just me, but they send all of us a letter each year. Because, you know, we're dealing with pre-licensing students that are taking their state exam during that time. Ronnie, that's when you took yours, right? During the renewal period.
Yeah.
So the question is, do I have to pay the application fee and then 2 days later pay the renewal fee? So they always send us a letter and say, you know, send this to your people to help address it. And that's pretty much what it says. So
Yeah, and
yeah,
I'm
it
looking at
sounds to
my
me like
pocket.
you got lucky this year.
Yeah, I'm looking at my pocket card, the digital, and it says expires 6/30 of 23.
So I would screenshot it, print it. Yeah.
Oh, I have it on my phone. I have it.
So when they
So-
find it, you know, no.
So Deborah, based off your license number, is that your original license number for where you did it back in 06?
Yep.
Yes.
Okay.
Yeah. If you come and go, they're always going to reissue. That number is yours forever and ever and ever. Yep.
And then
So,
Lane, I know it's funny because Lane called me, she goes, how do you have such an early number? I'm like,
yep.
2006.
I had a guy in my last class and he had like a something like a 196, you know what I'm saying? So similar situation. He gotten his license however many years ago and then, let it go. Deborah, you even had your license before I did because I'm 264. So you even
Yeah.
I got mine in 08. You said 06. So I got mine, in 08. So yeah, and again, if you ever let this license go active or expired, then and you redo it, reinstate it, then they're going to just give you that same number. So this is yours forever and ever and ever.
Yeah, a lady in my pre-license, and I brought her in to the Tate firm. So yesterday was her first day, and I asked to see her license number because I was curious. Of course, I jumped on my exam probably quicker than anybody else in pre-license, and I know she was
Ever.
at least a week or 10 days later. So I was curious how many people have been licensed between her and me. So her number is 340-661. So it was 101 people
Oh my gosh, you
licensed
guys
in her
were,
license.
you were walking out the door and she was walking in.
Well, but I thought 101 was a big number, just in a week or so.
No. I will share this with you guys that every once in a while, you'll bump into an agent, you'll meet them or do a transaction or see them in CE that has a 5-digit license number. And when you come across those agents, respect. That's all I have to say about that. Respect. They've been in it for a long time. If they got a 5-digit number.
Yeah, we've got 2 in our office that's 5 digits.
Respect. Buy them a coffee or something. They've been in it for a while. So reinstated an inactive license. If your license goes expired, how does your license go expired? Remind me how your license goes expired.
You don't pay.
You don't pay the fee. So failure to pay the fee means on July 1st, the stroke of midnight on July 1st, your license is expired. How you reinstate an expired license, it depends on how long it's expired. If it's expired for less than 6 months, then you pay the renewal fee and the reinstatement fee. So 2 times the amount, $90 instead of $45. And then you have to submit the license activation form. So you wake up on July 1st and you call the commission and you say, I forgot to pay. What do I do? They're going to say you owe us $90 and you got to do the activation form. If you're expired for 6 months to 2 years, you pay those 2 fees. You got to come back and take 1 post licensing within 6 months, or you go back to PSI testing center and sit for the state exam again. If your license is expired for more than 2 years, call me and ask me when my next pre-licensing class starts. Because we got to, and Deborah, that's what happened to you, isn't it? You had to start, bless your heart. You had to start all over. And that hurts me every time I hear somebody, I'm so sorry. You had to go through that again. But next time you'll know, just pay the fee, just send in the $45 and you can prevent this from happening at least.
It's just, for me, it was a matter of, I was working for BB&T, and then I was promoted to an officer of the bank, and I was doing really well, and I was just going to stick my career there. When I got it in 2006, I was not very happy with what was going on there, and I was like, I'm just going to get out of this corporate space. And so I stayed for 18 years. I was with BB&T for 18 years, same division. After all that was going on, I was receiving promotions about every year and a half, just doing different things. And I was like constantly evolving, and I loved that, but at that time I was like, I just don't see a path where I'm going. I feel like I'm locked in here. And so when all the other started open, I was like, well, that's the only reason I was wanting to kind of make a change. And then they sold our division in 2000. That's 2020. And then I was like, never again. I don't want someone else taking control and can tell me one day I'm great, and then say, oh, but we're going to sell it, and we've only negotiated for these type of roles to move forward with the buyer.
Right.
And I'm like, well, I don't like that. so I'm done with corporate America. I'm done with not having control.
That fork of road of life took you away and then it brought you back, didn't it?
Yeah, like,
That's
no.
very common.
And that's kind of why I'm here also. I spent over 18 years as senior vice president of a furniture manufacturing company, working with very large clients. And the owner wasn't keeping up with his financing. And the older he got, the more ornery he got, the more people he pissed off. Whether bankers, customers, vendors. And so, and he wasn't honest with me about the financial situation. So he ended up, and dates are important, he ended up filing Chapter 11 reorganization on February the 3rd, 2020. And then COVID hit.
Oh,
And went from 11 to 7 and boom, done. So I'm like, and I've had a place marker. I'm president of another brand, but I'm sick of working from home. I need to interact with people. I've spent all my life going somewhere every day, and the home office is not where I need to be.
right.
No, I'm right there with you. It's interesting because I currently bank still with Truist because I was with them for 18 years. All my stuff is there. You know, my fiance is a diehard Bank of America, so at some point I will be switching over to Bank of America, but not yet. But when I go in to do business downtown, the manager of the branch, which I was not a branch person, I was corporate. I worked out of a corporate location. She's constantly asking me to come work for her there, and I'm like, she goes, I'm telling you, I will do the paperwork. You can come in and start tomorrow. And I'm like, I mean, I could, but no, not doing it.
Give this a shot. You know, you guys, what I'm hearing you both is you're tired of working for the man and now you're here working for yourself. So,
But
well,
it's scary. It's scary at the same time because it's just getting traction, you know, getting that first one under you. I will say I'm in a position I don't financially need it.
That's good.
So I'm blessed in that matter, but I want it. And I want to be able to contribute, and I feel I need to, even though I don't have to, but that's what I've always done. And so I just got to get that one, Julie.
Well,
and then another, and then another, and another, you know, they'll follow.
But I mean, we're not kids. And one of the things that is attractive, of course, you know, I've always had an interest in real estate and bought and sold a lot, but this is something that I can do for as long as I want to do.
That's
so
right.
Like you got mandatory retirement ages and things like that. And so, yeah.
Yep.
That would be part of the decision.
Well, good. It's funny how both your stories are similar-esque, you know, how you're, and honestly, you guys, real estate is a very common second career. People come from wherever they started and they want something different. I can't see myself doing this for 20, 30 more years. So retirement, whatever, 10, whatever. So let's give this a shot. So I think
I've got time for one more really good career. One more.
What's that going to be? Have you decided yet?
Well, it depends on how the test goes today.
I will say, Julie, when you were talking to the early start of the discussion about family supporting and all that stuff, I mean, Jabu is always telling me, he says, baby, I'm going to be your open house guy. I'm like, what do you mean by that? He goes, I'm going to go, I'm going to vacuum beforehand, and I'm going to put the cookies in the oven. I'm going to make them, I'm going to go get the cookies for you. And I teased him. I said, well, normally we might need 24 cookies, but if you're doing that, we're going to need 3.
Get to bacon. That's awesome. That's awesome. That's funny.
Oh, yeah. He's very supportive, and he's just constantly like, I can't wait till you get that opportunity and we get to do this. I mean, he's
fun.
And he's like, and I'm gonna make dinner. I'm gonna make the dinner. I'm doing that while you're working. He's all about it, which I just love. Awesome.
That's awesome. That's awesome. So
now the kids on the other hand, they still want mama.
Right. All right, let's see. Inactive or expired. You guys good? Any questions? How you reinstate? Okay. Provisional broker, real quick. I call you guys my brokers with training wheels. you can't ride your bike until you have your training wheels just yet, right? So your training wheels, let's call your training wheels your BIC, your affiliated firm. Once you activate with a firm as a provisional broker, you can do just about anything that a full-blown broker can do. You do have a few exceptions, but the key here, the trick is you have to be under the supervision of a firm. So if you all leave your firms today, right now, for some reason, you finish the test and you say, I'm going to quit, your license goes back to inactive automatically until you find another firm to affiliate with. You guys both know you have your 18 months to complete post-licensing. Don't let this time get away from you. We know time goes by fast. Yes, yes. You know,
The older you get, the more you realize that.
Just watch kids. That's exactly right. So 18 months will be gone before you know it. So just don't let this time get away from you. Guys are not going to grant an extension. So they may grant an extension for a hardship, but a hardship is, you know, active military deployment. A hardship is not, I got busy and I forgot. Okay, so just, I know you're getting in your training, you're getting that first transaction closed. I know you guys are getting going, so just don't let this get away from you. Unfortunately, post-licensing does not count for CE. It's two different departments down at the Real Estate Commission. Some people think, well, if I do post, then I don't do. No, they are two separate things. Post-licensing is for those of you that just got your license that need a further understanding of agency, contracts, closings, and license law and commission rule. CE is for all of us across the state. Now, you guys know, again, the commission's renewal period is, excuse me, the fiscal year is July 1st to June 30th. And we said the renewal period is May 15th to June 30th. You don't have to do CE your first renewal period. So whatever day you got your license, the first time you hit May 15th, you don't have to do CE that year. You can, there's no rule that says that you can, but your first renewal period, you don't have to do that CE. You guys get your first year off. Pay the fee. Always pay the fee, but you get that first year off of CE. And speaking of CE, we do 2 a year. We do an update and elective, everybody across the state. So the update, again, is the opportunity for the Real Estate Commission to get the same information out to all of us. I think last bulletin I saw, there was over 104,000 licensees in this state. So that's a lot of people for the Real Estate Commission to get information to. And one way they can do that is through the update course. If you're a provisional broker or a full broker, you're going to do the GenUp, the general update, also known as the GenUp. If you're BIC eligible or the designated broker in charge, you're going to do the BIC-Up. Failure to do your right one means you won't get credit. You won't get CE credit for it. So you guys could go take the BIC-Up today if you really wanted to, but you're not going to get credit for it. You got to do the right one to get that update credit. And then we also do a 4-hour elective. The electives are a topic of your choosing. There's a cajillion approved topics out there. I'm going to venture out there and say, pick a topic and you can probably find an elective class for it. If you want to know more about, you know, there's one on the contract maze and working with buyers in this crazy market, and what else? There's what would the judge say? There's a 4-hour elective on mold. You can spend 4 hours learning about mold. So across the state, you know, that's one thing. Another thing that Zoom has done for us, I could take a CE down in Wilmington from a school offered in Wilmington now, right? Without having to drive down there. So kind of open it up. And when it comes to the elective, I encourage you to find topics that whatever your niche is, or whatever you're interested in learning more about, use this as an opportunity, 2 birds, 1 stone kind of thing, to not only knock off your elective, but learn green housing, sustainable housing, you know, that kind of thing, working with seniors, working with first-time home buyers. Pick a topic.
Are these generally done the same day?
It's up to the school. I think a lot of times they are offered on the same day, so you could take one day and knock them both out. Me personally, drives me nuts. I stand, I don't sit, right? I'm on this side of the desk. So for me, the idea of sitting and being a student for 8 hours in one day, just no, thank you. So I choose to break mine up. I do the update and then I do the elective, but a lot of schools will offer them, both at the same, on the same day. It doesn't matter. As long as you have them done when's our CE deadline?
June 10th.
June 10th, every single year. Every single year. Y'all don't let this date get away from you. Again, June 11th, real estate schools' phones are blowing up. I forgot to do CE. What do I do? Well, here's the deal, you guys. The Real Estate Commission has put a blackout period on CE from June 11th to June 30th. No school, no education provider in the state of North Carolina can offer CE for credit after June 10th. The reason for that, what I just say, 104,000 active or licensees, all of us are renewing at the same time. The individual licenses are renewing, the firm licenses are renewing, educators, education providers, the schools, everybody's renewing. And they're processing a lot. So they got to cut that CE off on June 10th to make sure they get everything in by the end of their year on June 30th. So if you miss your CE on June 10th, you missed that deadline, pay the fee. So on July 1st, your license will be inactive. And then the only thing you can do is after July 1st, find a school to get your CE, to get caught up. Some do offer CE in July. I think Lane did this year, actually, for people that, those holdovers that forgot. But you got to find somewhere that's offering CE as soon as you can, so you can get your license back active again.
Do they test on the CE?
The only time you would see a test in CE is if you do the elective asynchronously. So what you and I are doing right now is synchronous. We are only separated by distance, but not by time. Asynchronous is like self-paced. You log on and you go, through different modules. So if you do asynchronous, you get like 30 days to do a 4-hour CE class, but they're going to give you a little test at the end of each section to make sure you're sitting there. But if you are sitting in a classroom or if you're on Zoom, then you won't have a test. Update is always going to, well, for now, update is always one-on-one. Again, may that be sitting in a live classroom or Zoom. Update is not approved for asynchronous yet. Is that going to change? I don't know. Questions on post CE? Good review. Blows my mind. You guys know when we start post licensing and I say, tell me if your license is active or inactive, and if you're active, what firm you're affiliated with. And it blows my mind how many times post licensing students will say active, no firm. And I'm like, you didn't get that question right, did you? So if you didn't get it now, hopefully we get it now, right? If you didn't get it then. So that gives me an opportunity to know how much time I need to spend on that, making sure we understand. Okay. That's it. That's all we have to talk about. So we're going to go ahead and take our break. We come back, we're going to do our exam review, exam expectations. I do want to go through the review pretty quickly so we can get you guys started as close to 1:30 as I can. You guys get 3 hours, but obviously no matter when the exam starts, you always get 3 hours, right? So if we don't get started until 2 and you're still going at 4, you still have till 5. Does that make sense? So I'd like to get us started as close to 1:30 as I can. So let's take 10. We come back, we'll kind of zip through this exam review so that'll have you time to get going on that exam. Fair? Is that good? Okay. All right. So what time? It is now 12:35. So let's come back at 12:46 and we'll review. All right.
So I had to go across the street and fix the TV for the old couple who lives over there because the Braves are playing.
Oh, man.
Yeah.
We are not Braves fans in this house. We are not Yankees fans in this house. So I wouldn't have, no, I would have, but it would have been hard to do.
Yeah.
All right. So let's review. Let's kind of recap some of the bigger, more important points that we've talked about. Again, very short time together, but it seems like it's so long ago, but it really wasn't. It was only 3 weeks ago, wasn't it? We started our journey talking about the essential elements, the essential ingredients for a valid contract. So validity of a contract. And the judge is looking for these things when trying to determine if a contract is valid or not. The essential elements, that's what we mean by that. How valid is it? So the judge is looking for mutual assent, which we'll talk a little bit more about in just a second. Any legally binding contract is going to have some form of consideration. There are no free promises. So consideration typically looks in the form of money. But I think the important thing to realize is that consideration is anything of value. You know, is managing my duplex in exchange for free rent, is that free rent a form of consideration? Although you're not paying me money, you're still giving me something of value. So
Yes.
Keep that in mind. Consideration, it's not necessarily a dollar sign. Legal capacity of the parties. Both parties entering into a valid contract have to be of sound, sober mind. They have to have that mental capacity to contract. You have to, a legally binding contract cannot be for an illegal purpose. So the contract itself has to be a lawful objective. And then Contract steps in and says, in order for this thing to be valid and enforceable, it needs to be in writing. So with our mutual assent, our meeting of the minds, this is our offer and acceptance. Mutual assent, meeting of the minds, offer and acceptance. We're all saying the same thing here. Two parties have to come together and agree to enter into a contract together. The person making the offer is the offeror. The person receiving the offer is the offeree. We talked about this magic moment in time, which we'll see again in just a second, where that offer becomes a contract. We have to have the last offeree's acceptance, and we have to have communication of acceptance go back to the offeror. The person making the offer needs to know that their offer has been accepted. And how do we validate their offer has been accepted? We have a signature. Remember, if you got verbal, you got nothing, right? So in order to have this legally binding contract, we have to have that acceptance and signature. And this is where we kind of talked about the line, and particularly we talked about bringing agents into the transaction and what our role is. Communicating to me when it comes to offer and acceptance, communicating to me is the exact same thing as communicating to my client. So in this scenario, let me get my Zoom bar out of the way. In this scenario, we have the buyer as the offeror making the offer to the seller who's the offeree, and they have agents. The buyer has a selling agent, the seller has a listing agent. So the buyer makes the offer to the seller, and for simplicity, let's just say the seller accepts. They agree to all the terms exactly how they are. So the seller signs, and then the seller calls their agent and says, hey, I've signed. Are we under contract? Seller calls their agent and says, hey, I've signed. Are we under contract? No, not yet, right? Now the listing agent calls the selling agent and says, my guys have signed. Now are we under contract? Yes, because that communication crossed the line. What's the very next thing the selling agent should do?
Call the buyer.
Call the buyer and tell them the good news, right? And this conversation isn't, are you sure you still want? This conversation is, you got it. We're under contract. Congratulations, because that communication crossed the line. Again, when you see this in just a bit, this test question in just a bit, I do suggest drawing this out, because you're gonna you may have some counters, right? So in the end, and they're not going to say buyer and seller. So in the end, you need to know who the last offeree is that needs to sign, and who the last offeror is that needs to receive that communication of acceptance. And also remember too, you guys, when it comes to communicating, I only need communication to cross the line once. It's the first time that it crosses the line. Anything after that is just follow up. So if I send you an email and then I call you, that email is what put us under contract. So just keep that in mind. It's the first time that that communication crosses the line. Again, I think if you have the visual, it'll help you see that. We good on that? Questions on that? Good. Legal capacity, as we said, we have to have legal capacity of the parties. If the parties don't have legal capacity, then they could make the contract voidable. A contract that becomes voidable, the contract itself is valid, but it becomes voidable because one party has the right to go and stand in front of a judge and say, I shouldn't have to complete this contract. One party can make it voidable. The contract is still valid. It would still hold up in a court of law, but one party goes to the judge and says, we should make this voidable. We talked about some examples of those parties, a minor, anybody the age of 18. The judge can't force a 17-year-old to follow through with a legally binding contract. So they would make it voidable. Somebody that's declared mentally incompetent in fact, but the court hasn't weighed in yet. That individual can make the contract voidable. We'll be reminded in just a second about what happens when the court weighs in. Legally declared mentally incompetent. And then anyone that was intoxicated or under the influence at the time they entered into the contract. If they can prove to a judge that they were not of their sober mind, the judge may not expect them to carry through. They could make it voidable. We also said mistake of fact may make the contract voidable. Again, I'm not a judge, but in order for you to make it voidable, you would need to prove to the judge that this mistake involved a material term. It was a mutual mistake. It was a mistake made on both sides, and it's not fraud. Remember, we talked about the difference in fraud and misrepresentation. Fraud has intent. Misrepresentation is just, oopsie, it was an accident. So if we can prove that mistake of fact to the judge, they may make that contract voidable. And then somebody that's been declared mentally incompetent by a court of law, the contract would become void. The judge is going to rule that they didn't have the mental capacity to enter into the contract to begin with. We didn't have a true meeting of the minds. We didn't have a true mutual assent because we didn't have the legal capacity. So everybody good with that? Both have been declared by the medical profession as legally incompetent. If the courts have not weighed in, it's voidable. If the court has weighed in, it's void. Okay. We talked about our electronic signatures and documents, electronic transactions, particularly that's managed by UETA, Uniform Electronic Transactions Act. We got a state version, which is the North Carolina UETA. What the UETA says is that signatures are legal so long as the party agree to use electronic means. If we click on those terms and conditions in dotloop or SkySlope, then they're going to tell the parties, once you send something out for an e-signature, it's going to tell them that once they e-sign, even though it may not look like their actual signature, they've agreed to allow that count. That disclosure is required, so dotloop and SkySlope do satisfy those requirements. And when it comes to electronic forms of communication, communication of acceptance happens upon receipt. Once it hits the recipient's inbox, it doesn't matter when you send it, it doesn't matter when I open it. Communication of receipt happens once it hits my inbox. We talked about our sales contracts in chapter 11. The standard forms that we use, that we're provided to use, are those that are jointly approved and authorized by the North Carolina Association of Realtors and the North Carolina Bar Association. Only realtors, only members of NAR can use these forms. If you're not a member of NAR, you can't use the form with the realtor logo. So if you're a non-member, you'll have to have an attorney draft something up for you or your firm. You know, if you have your, let's say, your one-man show and you choose not to join NAR, then you'll have to have an attorney draft something up for you guys to use. By the way, just FYI, NCAR and NC Bar Association create all of our forms. I think a common misconception is that our forms come from the North Carolina Real Estate Commission. And it's important that we know, if nothing else, know where to find them. NCAR is who does our forms. The only thing that the Real Estate Commission does is our working with real estate agent disclosure, the RPODs, and the MOG. RPODs, MOG, and working with real estate disclosure comes from the commission. Everything else comes from NCAR. We as brokers, we don't belong in the offer to purchase and contract. We are not a party to the contract. The parties to the contracts are the buyers and the sellers. Particularly, the commission says we cannot have any mention of our commission or compensation, rebates, bonuses, anything like that. Those are agreements. Our money are agreements that we hash out in our agency agreements. So that's where we talk about our commission and referral fees and kickbacks, bonuses, etc. The other thing specifically that the Real Estate Commission says that is prohibited in the offer to purchase and contract is any attempt to disclaim our liability. So if my buyer waives the home inspector, I got the professional services disclosure that I can use to acknowledge that waiver. I'm not going to try to slip that into the offer to purchase and contract. Okay. Remember, you guys, our job, the only thing we're allowed to do is fill in the blanks. And when we see a blank, those blanks are asking for a very specific thing. So just because we see a blank doesn't mean we can put any old thing in there. We need to pay attention and make sure that we're properly completing those forms on behalf of our buyers and or sellers. So then we had I'd call it a detailed review of our offer to purchase and contract standard form 2T. Some of the provisions that we talked about, full legal names of all of the parties, all of the sellers that need to sign the deed to convey and their spouses, and all of the buyers that are going to purchase and their spouses. Don't put people together. My name is not Mrs. Ryan Campbell. If you were writing the contract for us, you would have Ryan L. Campbell and Julie A. Campbell. You can identify us as husband and wife if you choose, but do not lump us together as Mr. and Mrs. Okay, we each have our own name. We get our own identity. The contract defines special assessments. Special assessments could be from an HOA. Special assessment could also be from a governing body. Maybe they're going to hook a whole neighborhood up to public sewer, for example. If there's special assessments on the table when we go under contract, the contract tells us how to proceed with these. Anything that was confirmed prior to settlement is the seller's responsibility to pay, whether they are due in one lump sum or future installments. What we're looking for is if it was confirmed prior to settlement, that's the seller's responsibility. If it's proposed and it won't be confirmed until after settlement, now it's the buyers. At that point, we can call them the new owner. Now they own the property, so when that special assessment becomes confirmed, they'll be responsible for it. The contract spells out what happens when the buyer terminates within their due diligence period. The seller almost always keeps the due diligence fee. The only time the seller may have to give that back is if they are in breach. So if the buyer terminates within their due diligence, the seller will keep the fee. The buyer will get their earnest money deposit back. If that buyer terminates after due diligence, now the seller gets both. Seller keeps the due diligence, they will get the earnest money. Those two together are known as the seller's liquidated damages. And as the contract tells us, that's the seller's sole and exclusive remedy. So be happy, make sure your sellers are good with that due diligence and earnest money, because they need to understand if the buyer just does not show up for settlement, that's it, that's all you get. So make sure they're good with those amounts. The seller's biggest obligation is to pass marketable title to the buyer. This is why the buyer hires an attorney. The buyer's attorney represents the best interest of the buyer. And the best interest of the buyer is making sure that their client is getting clear marketable title. So the attorney will do the title search. The attorney will find any kinks in the chain, if you will, cloud on the title, any defects, and they will work with the seller to get those cleared up before settlement, So what they are in fact handing their buyer client is that clear marketable title. The seller also has a duty to provide various disclosures. So we talked briefly about the RPODs and the MOG. You guys will get into a little bit more of those in 302. You'll go through them, you know, a little bit more further. But the seller does need to provide seller disclosures.
This is 302.
303, sorry, 301. What'd I say? Whatever.
302.
301. So you'll talk more about the RPODs and the MOG in 301. The thing about the seller disclosures that a lot of buyers don't like, these are mandatory forms with optional disclosure, which means the seller has to complete them and they have to provide them, but they don't have to disclose anything, do they? For the most part, they have the option to say no representation. Regardless of how the seller completes, the buyer should always be encouraged to do their inspections and their investigations. Remember, we saw in the contract that the buyer represents whether or not they have received these disclosures or not. And if they have not received them, then that could give them, how many days do they have to cancel? Could give them not 5, 3. There you go. There you go. So it could give them 3. So if they have not received it, again, you guys, they're not acknowledging that they're satisfied with the way they completed them. They're acknowledging receipt. They were put in their hand. Like it or not, you received it. And that's what they have to acknowledge. The contract does allow for assignments as long as the parties agree. An assignment can happen as long as the parties agree. So as long as buyer and seller agree, there is verbiage for that in our contract. And our contract also tells us that if either the parties pass away while we're under contract, their heirs are expected to carry out the terms. And if they can't or won't, then they suffer the consequences of breach as laid out for that party. Death is only an out when you're negotiating the offer. Once you're under contract, you're in. Your intentions were clear because we have a legally bound signed contract. Seller is to provide reasonable access to the property through closing. They need to allow the buyer to conduct their due diligence period, verify satisfactory completion of any agreed upon repairs, and of course, do that final walkthrough. This seller's responsibility to provide reasonable access does include providing existing utilities. So they can't cut off services as soon as we go under contract. The home inspector can't inspect without power and water, right? That's up to the seller to leave those utilities on so they can do their inspections.
We was somewhere in this conversation was talking about leaving propane in the tank. And obviously I did a nice job on the house that I sold and closed January the 14th, because today the buyer reached out to me wondering who the propane company was.
January, February, March, April, May, June, July. So they got a good, they got a good 6 months out of you. Again, you guys, the seller can't contract and then not allow the buyer's home inspector in. I mean, that's reasonable, right? They can't not allow the appraiser in. The seller needs to understand, even though once we go under contract, they still have to provide reasonable access for the buyer to, you know, do their inspections and investigations. And that goes the whole way through the final walkthrough, which ideally is as close to settlement as we can possibly get it, on our way to the attorney's office. The contract addresses due diligence, repairs, and negotiations. As we have mentioned, this has been a problem topic down at the commission. That's probably the reason why we see it numerous occasions. If the seller agrees to do any repairs, those repairs have to be in writing, signed by the end of our due diligence period. The repairs themselves don't have to be complete until prior to settlement or whatever arrangements the party makes. So after due diligence, we're no longer negotiating repairs, are we? Those need to be handled while we're in due diligence, and that's to protect the buyer. If the seller says, no, I'm not doing any repairs, the buyer has a decision to make. Now, knowing what I know, do I want to move forward with or terminate this transaction? And as always, with any repairs, any work, the buyer always has the right to verify satisfaction, verify that it's complete. We talked about fixtures in the offer to purchase and contract. Can you guys see this okay? This is an old list. I now know I need to update this, and so I'll work on that because fuel tanks used to be in there, but it is helpful for us to know what our fixtures, anything's negotiable, right? Anything can be agreed on. So if the seller wants to take any of these, they can. We just need to let the buyer know that when this property conveys, these fixtures are not going to convey with them. If the seller wants to take any of these things and we don't have a exception, then the seller could be in breach, right? Because these things are considered part of the property. So we go under contract and nothing's exempt, and the seller takes the blinds and the shades and the curtain rods, they could be in breach, right? Because they took part of the property. If they want to take these things, the storage shed, whatever, if they want to take these things, then we need to work that out in our negotiations. Okay, if you're using a different contract, the fixture list may look a little bit different. So always just make sure you're reviewing that. I mean, these things update, like I said, this just changed on July 1st. So I now have a note to change out this slide again. But all this verbiage about fuel tanks has been moved to that new section of the contract. So that kind of helped the fixture list a little bit. Again, we spent most of our time on 2T. That's the most common one, the one that we use the most frequently. 2T is the one that we're going to use for most resale residential transactions. We did also briefly look at 12T. 12T is our contract for vacant lot and land. We looked at 800T. 800T is our contract for new construction. You got to make sure you're using the right form. I don't know another way to say that. Always make sure you're using the right form. When in doubt, find out. We have resources out there. Both of you have a BIC. Both of you have peers in your office with experience that can help you. We have guidelines for completing all three of these. Did you know with your NCAR membership also comes access to a legal hotline? You can email an attorney through NCAR or call on the legal hotline and talk to or get a response from an attorney. So if your BIC's not available and you need a legal question answered, or if you and your BIC don't know, sometimes we don't know, right? So just know we got tools and resources out there. When in doubt, find out. Remember, you're creating legally binding contracts for other people. So make sure you're doing it properly. Make sure you're doing it right. We also briefly mentioned the agreement for purchase and sale of real property. This is our commercial contract. Ronnie, when you get into commercial, I doubt you're going to use this pre-printed form because most commercial transactions are more complex than the pre-printed forms we have available. So when Ronnie gets in commercial, maybe this applies, and if so, great, he can save his client some attorney's fees, right? But if it doesn't apply, then they're going to have to get an attorney involved to draw things up. The 2T is pretty clear, it kind of lays out scattered throughout, but it tells us various things that the parties are responsible for. The buyer is going to be responsible for their loan. They are responsible for paying the costs with their investigations and inspections. Can we ask the seller for help with closing costs? Can we ask the seller? Yeah. Right now, how much is the seller paying towards these expenses? Zero. Somewhere down the road, the seller's going to be paying these again. So we can always ask the seller. It's a completely negotiable clue. What I'm saying is the buyer's responsible for them. Usually in this market, the buyer pays for them, but there may be another market that the seller does. Closing attorney, the buyer will pay for that. Why? Because the buyer hires the attorney. So the attorney is working for the buyer and the lender. And then any damage to the property caused by the buyer or their agent. So we gave the example of the home inspector damage in the property. The buyer's going to be on the hook for that. And then the other thing that we briefly mentioned a few minutes ago, special assessments that are confirmed after settlement. But after settlement, we're done using 2T, right? But it does spell out anything that's proposed on the table that's confirmed after settlement is now the buyer's responsibility. Now the buyer being the new owner. The contract tells us that the seller is typically responsible for the deed preparation fee. The seller pays to have the deed prepared. The buyer pays to have the deed recorded. We got to think about whose best interest it is. Seller prepared, buyer recorded. The seller also pays excise tax. And the other big thing not spelled out in our sales contract that the seller is usually responsible for paying, but it is in our agency agreement, is our money, our commission. We're always going to debit the seller unless we're told otherwise. Then we looked at various addenda. The backup contract addendum, this is what we're using when you're presenting an offer on a property that's already under contract. That backup contract addendum upon acceptance will place this buyer in a backup position. And it's kind of funny to think about it, but what's happening is that backup buyer standing there, fingers crossed, hoping that the primary terminates, right? Because if that primary terminates for any reason, they're in. So the backup contract addendum we present on a property that's already under contract. Lead-based paint prior to what year?
1978.
1978. All residential properties for sale and for lease. Anything built prior to 1978 should have the lead-based paint hazard addendum. I'm not telling you this home has lead in it. I'm telling you because of the year that it was built, it may have lead in it. The buyer is encouraged to do their own inspections. This is one of the times that caveat emptor, this is a very rare exception to caveat emptor. And what the lead-based paint hazard addendum and rules say, if the seller is aware and has reports of lead in the home, they must present those to the buyer. They must provide that to the buyer.
But they're not obligated to do anything about it.
They're not obligated to do anything about it, but this is one thing that they have to disclose. They can't hide that if they know. No representation is not an option here. We looked at response to buyer's offer. This is let's think of it as like the memo from the seller to the buyer. The buyer has made an offer and the seller is responding. This form is not a contract. This form is not a counter offer. It even says this is not a counter offer. This is the seller just responding. Remember, we had three different, we can either reject their offer and put their cards on the table. They can tell the buyer they've called for highest and best, or they can say thanks, but no thanks, have a nice day. So the seller is just responding to the buyer's offer. We looked at the additional provisions addendum. This is the one that had the additional provisions. If it's on the sewer, for example, if there's a modular home on the property, if there's a pool or a spa that needs inspected in the middle of wintertime, there's various different things that this form covers. We use this form at the time that the offer is presented, not when we're under contract. You with me? So I'm presenting the offer. And remember, another one of the options we have on this form is for the buyer to ask for repairs. These are things that we can see when we're viewing the property. So we know this window is broke. I'm going to present the offer with that repair request. We go on, the seller accepts, they're now contractually obligated to replace this window. We go under contract. The buyer proceeds as normal. They still should be having inspections and investigations done. They can still ask for repairs doing the due diligence repair request, right? But we're just using this. We know something's broke or fit or not fixed or not working or something we want handled. So we're going to present this at the same time we're presenting our offer. Questions, comments? So what if a form doesn't fit a situation? What if either party to the contract wants to add or amend or delete their own verbiage? What it went, not if, but when your client asks you for legal advice, I'm a heck of a lot cheaper than an attorney. So they do ask. What if you're in a position to do an installment land contract or an option to purchase? The answer to all of this is have them call their attorney. Again, buyers and sellers don't know our limitations. So they're asking questions to learn, and it might be that our answer is, that's giving legal advice. I need to advise you to talk to your attorney. You and I need to know the limitations, not them. Submitting offers to sellers, I think we're good on this. We present all offers to seller. Low ball, insultingly low offer to the seller, I have to present it. Installment land contract, option, preemptive right. We have to present everything. I'm not the one making the decision to sell this house. I need to give them all of their choices, all of their offers. And the rules say that we need to do so. Remember, the law of agency says as soon as possible. Real estate commission says immediately. Real estate commission gives us a little bit of wiggle room here, right? But they both say what? Immediately, as soon as possible. The commission just gives us, but in no event later than 3 days. I guess my rhetorical question to you is, why the heck is it taking you 3 days to present an offer to your seller? Maybe in an extreme situation, but for the most part, you get an offer in your hand, call your seller. You got good news, unless you have insultingly low offer. Go ahead and call them anyway and get it out of the way. We talked about submitting multiple offers to sellers. We submit everything that we have in our hand as soon as possible. So once you get something in your hand, submit it to your seller. Get something, even if you call for final and best, the suggestion is that we still submit them to the sellers ASAP. If we've called for best and final at 5 p.m. tomorrow, I'm going to start getting offers in. I'm going to send them as I get them. And then tomorrow at 5 o'clock, we're going to sit down and talk about all of them, right? But I'm going to send them. I'm going to present them as I get them. We cannot present them in any particular order, guys. I cannot favor one offer over the other. The highest priced offer, I can't only present that one and say, this is the highest price, just look at this one. If it's a buyer coming from another agent in my firm, better yet, if it's a buyer coming from me, I cannot favor offers. I need to let the sellers keep them. I love the Excel sheet. It keeps them focused on the numbers, right? It keeps them focused on the facts and not get bogged down in some of this other stuff. We can't share terms of an offer without the permission from the offeror. So the person making the offer, in order for me to say how much they made, what their offer was, I have to have their permission. Is anybody in their right mind going to give you that permission? No. Why would I give you that for fuel to beat me, right? So we can't pit agents together, buyers together. We can't make them compete. The buyers need to bring their best offer. Maybe my offer is better than yours. I don't know, but it is your best offer. The very fact that we have multiple offers on the table is not a material fact. I don't have to disclose that I have multiple offers. Whether or not we disclose that is up to the seller. That's a conversation we have with the seller about whether or not they want to share. You okay down there? Okay. Let's make sure she wasn't rubbing her head. Just your eyes. Okay. I just looked down and saw.
No, my air conditioning is out, and so we have fans blowing around, and then my
Oh,
eyes,
goodness.
we're getting a new air conditioning unit tomorrow, but right now I have fans and it dries my eyes out.
Oh, yeah. Okay.
How come the
Just wanted to make
AC,
sure I wasn't giving you a headache. Yeah.
why does the AC never go out in January?
Well, so we have two. One went out last year as we were buying it for my ex, and
Oh,
because
no.
we had finalized this closing, I was able to get him to pay half of it, so he did.
Nice.
But this year, we knew the other unit was going to go out at some point, but we chose to wait until it did because we don't know how long. We could have got a couple years out of it still.
Exactly.
But it's 19 years old, and it went out on Saturday, so we've been without AC. We've just got a ton of fans in every room just blowing the air around.
I feel you. We got our new unit about 2 or 3 weeks ago, so I was there without a unit. So I feel you.
Yeah, but you never know. You never know how long it's going to last.
Eyes. Oh my gosh.
Okay. We talked about the earnest money. The earnest money, its whole purpose is to show the buyer's good faith. The buyer is proving to the seller that they're a serious buyer. I'm genuinely interested in buying your house. Let me prove it to you by putting money in an escrow account, my money in an escrow account that you know that you can use for collateral if I don't carry through. If the offer never becomes a contract, then the earnest money needs to go back to the buyer. So we talked about situations where you may be asked to hold the earnest money while we're negotiating. If that offer never becomes a contract, the buyer doesn't owe anything until a contract is formed. So if that offer never becomes a contract, then we need to get it back to the buyer or dispose of it according to their instructions. Do they want you to write void on it and send them a picture? It's their check. So what makes them feel comfortable knowing that it's not floating around out there? You guys as provisional brokers, if you're ever asked to hang on to earnest money while you're negotiating, you can't. Provisional brokers cannot walk around with somebody else's money. You need to get that money immediately to your broker in charge. Full brokers should not walk around with somebody else's money. Guys, please remember, when you have somebody else's money in your hand, it is your responsibility. So my suggestion to you is get it to where it needs to go. Get it out of your hands and get it out of your responsibility. And then the earnest money rules say that we have to deposit, or the escrow agent has to deposit any earnest money within 3 banking days from receipt or contract formation. So this is important, again, in those situations where you're asked to hang on to earnest money. You're not going to run and get it in the bank. You're going to hang on to it until you have that contract formation. The contract's formed. Now you have 3 days to get it in the bank. Again, the buyer doesn't owe any money until this contract is formed. If the contract's not formed, they don't know anything. And then we talked about a whole bunch of things that the buyer should be encouraged to do during their inspections and their investigations. The contract does spell out a numerous of things that the buyer should be encouraged to do, inspect and investigate. Remember, they're trying to learn as much about the property as they possibly can, because the buyer has to decide if they want to move forward with the transaction or not. And how can they make that informed decision without learning about the property, without doing investigations and inspections? If they're doing what we advise them to do, and they're doing as many of these inspections as may apply to the situation, they're learning about the home. They know what they're getting themselves into. And it might be when this is broke and we need a new roof and the AC unit is 19 years old and this and everything else, those costs add up, right? And the buyer may say, I know in the next 3 years, I'm going to have to put $30,000 down. So are they willing to walk away from their $5,000 due diligence to save $30,000? I can't answer that for them, but I can help them do those inspections and investigations to get that information so they can make that informed decision. I think it's also important that we remember that this list is not inclusive. So whatever the buyer wants to investigate or inspect, our answer is okie doke, let's do it. Because it's so simple. My simple philosophy, if it's important to my buyer, then it's important to me. So if they want to inspect this or investigate that, then we're going to do it. They're the ones buying this house. Once we're out of due diligence, we have this period of time between the end of due diligence and settlement. And we're trying to get some pre-closing matters done, some pre-closing matters taken care of. If the listing firm, or the real estate firm, I should say, has the earnest money, then we need to make arrangements to get that earnest money to the closing attorney. We talked about a couple of different ways that can happen. We can either send a check with the agent, or we can deduct the earnest money from the commission. And have that kind of worked out that way. But one way or another, we need to get those funds. Obviously, if the closing attorney is the escrow agent, they already have it, right? So we don't have to make those arrangements. This only applies for Ronnie, whose firm will hold the earnest money. Deborah and I don't have to worry about that. Closing attorney is the one that arranges for title insurance. They're the ones that offer their final title opinion. This is probably one of the last things that the attorney does before they record the deed. They arrange for title insurance by offering their title opinion. Closer to closing, or settlement, we need to notify the buyer of money to bring. Remember, it's got to be readily available funds. Your buyer cannot show up with a big bag of cash. I know that's pretty readily available, but we're going to need a cashier's check, wire transfer. A personal check isn't going to cut it. And then once that loan package is signed by the buyer, it goes back to the lender for final review. And upon approval of that final loan package, that is when the lender releases their funds. That is when the lender releases the loan amount. But they're going to make sure that all the I's are dotted and the T's are crossed. They're going to make sure that everything is handled. We talked about different settlement meetings, or different ways we handle settlement. North Carolina is a settlement meeting method, which means we have it handled by a settlement agent, also known as a closing attorney. So closing attorneys do still conduct our closings in North Carolina. We also talked about roles of non-lawyers. Non-lawyers can tell you where to sign. They can tell you where to date. Non-lawyers can receive and disperse funds. They can pay the parties after settlement. Anything that a non-lawyer, we're talking like paralegals here, anything that they do, they're doing under the direct supervision of an attorney. So they can be involved, and they usually generally are, but they're working for that attorney. They can't draft the documents. That's the attorney's job, for example. But they can assist the attorney. They can say, sign here, date here. And again, they can disperse funds after. And then we talked about RESPA. When you see RESPA, I'd like you guys to see the word settlement. RESPA tells us the cost to close. RESPA tells the consumer the cost to close. How much is it going to cost me to close on this property? And we decided that RESPA applies to most mortgage loans. We're just talking specifically about mortgage loans. Anything 1 to 4 family for residence, lots, mobile homes. And all lenders that make federally related mortgage loans, i.e. something that can be sold to Fannie Mae, Freddie Mac, Ginnie Mae, have to comply with RESPA. So pretty much anything we deal with, always loan-wise, has to comply with RESPA. We discussed several other ways that RESPA can protect the consumer. They're going to put escrow account restrictions. How many months are they going to collect on the monthly mortgage payment? How many months worth can they collect at once when you make your payment? Not when you make your payment. When you just one, that's right. So you take annual taxes divided by 12. That's how much they can charge you on your mortgage payment. They take the annual HOA, they divide it by 12. Now, Ronnie, how many months can they collect at settlement? 2. That's right. So to originate and start the escrow account, they're only collecting 2. They can't get greedy and collect more. RESPA, this is the one that hurts us. Prohibited kickbacks or referral fees to or from settlement service providers. And yes, you and I are settlement service providers. So we cannot give or receive a referral fee or a kickback for recommending a service. It's important to note that agent to agent referral fees are still allowed. RESPA has not touched agent to agent referral fees. Just make sure the person you're paying has an active license in their state. RESPA says we need to provide a written estimate of closing costs, the loan estimate within how many days of loan application? Within 3 days of loan application. And then we have to have the borrower's closing disclosure within how many days before closing? 3. They make that easy for us, right? They're easy to remember. And then you have that and then that HUD-1 settlement statement, again, 3 days prior to settlement. Gee, Julie, what's the big deal for violating RESPA? Well, you're looking at criminal fines. It could be up to $10,000 per violation. How's that $25 Amazon gift card looking now, right? Is it worth it? I don't think so. Imprisonment for up to a year, an injunction is a legal stop. You could face a lawsuit, and oh yes, please don't think that the real estate commission won't get involved and discipline your license. So again, I ask you, how's that $25 gift card from Amazon looking now for sending your buyer to this home inspector? It's not worth it. Guys, remember, RESPA says I can't accept $1 or a donut for recommending settlement service providers. They can try to give it, I can't accept it. Okay. And then we talked about TRID. TRID is the acronym of all acronyms. TILA and RESPA integrated disclosure makes up TRID. Buyer needs to receive that loan estimate within 3 days after loan application. TRID requires 2 closing disclosures, one for the seller, one for the buyer. Remember, the party we're protecting in this transaction, the party that the consumer that TRID is protecting in this transaction is the borrower, because they are the ones originating the loan. So technically the buyer can see the seller's figures. What TRID says is the seller can't see the buyer's figures. It's a consumer protection. And we have a duty to verify what we can. When you guys get your closing disclosures from the paralegal to review, the first thing you need to do is whip out your sales contract, right? And verify that purchase price and due diligence and earnest money. We don't know how to prorate taxes. We don't know how to calculate interim interest. We may not be able to verify all of the numbers on the closing disclosure, but I should be on the lookout for little red flags, right? If the attorney's charging my buyer $3,000, I should have a little red flag go up. Now, I don't know exactly what they're charged unless I call and ask, but I need to look out for numbers that look a little odd. And remember what we said, you can always whip out your calculator and add, right? So you can straight line add, make sure everything on page 1 adds up, and then everything on page 2 with the buyers and sellers debits and credits. We talked about changes to the closing disclosure. Not all change requires a new 3 business day count. They're pretty specific here. The only change that requires the lender to issue a new CD to the borrower and have a new 3-day count is going to be an increase in the APR by more than 1/8%, a change in the loan product, and the addition of a prepayment penalty. Any other change will require a new CD to be issued, but it doesn't require a new 3-day count. So when we find a mistake, if we find a mistake, then we just need to verify, just report it so we can get it fixed. We can't not report it. Don't worry about hurting somebody's feelings. You need to pick up the phone and call the lender, the paralegal, and say, this isn't right, get it fixed. And then we review the whole way back to 11:30 this morning. We talked about the installment land contract. Seller agrees to sell, the buyer agrees to buy, and the seller is the financing device. Remember the difference in this and seller financing is when the deed changes hands. So with seller financing, the buyer gets the deed at closing. With an installment land contract, the buyer gets the deed when the last payment is made. Seller's going to retain legal title. They keep that deed. The buyer has the right to live there. The seller has 5 days to record to protect the buyer, to protect them. The buyer has allowed 30 days to cure a default. And of course, we don't have a form, so we got to get an attorney involved. CYA, call your attorney. This morning, we also talked about the option to purchase. The optionor is the owner. The optionee is a potential buyer. This is our unilateral contract. We haven't agreed to buy. We've just asked for the option to decide. So we have a designated time period to purchase or not. The optionor decides, or excuse me, the optionee decides if they want to buy or not. There's 2 forms of consideration. You got your purchase price and the healthy option fee. All the terms are decided at the time of agreement. So if the optionee decides to buy, they know how much, when. And then statute of fraud says it needs to be in writing and to be enforceable. Connor Act says it needs to be recorded to be enforceable. We also talked about license status. Your license is current. Why? Because you paid the fee. So you pay the fee, your license is current. A current license could be active or inactive. Active or inactive usually comes down to education. Where are you in your education? For you guys, provisional brokers, you have that added layer of being affiliated with a broker or not. Failure to pay the fee means your license is expired. So licenses, I should say, are either current or expired. A current license can be active or inactive. You guys have 18 months to complete post licensing. You have to be affiliated by a BIC to be active. You get your first year CE off. Post licensing is not CE. Again, two different departments of the Real Estate Commission. You can't get CE credit for doing post. You can't get post licensing credit for doing CE. Two different things. And then we talked about, lastly, various things that we prorate. So are you guys good with proration? Are you feeling good about that piece of it? Okay, so real property taxes, of course, is the most common. If it's in an HOA, HOA dues could be monthly, they could be quarterly, they could be annually. The problem will need to tell you. And then we could also prorate rent. Remember, the seller is responsible for that day of closing. So whether if we're doing a credit to the seller, then they're going to keep money that day, right? And then the buyer is responsible for tomorrow. Questions?
In the next post licensing class, how can we guarantee it only be one of two students?
Call Lane. I think the class I taught right before the pandemic, we were in person. I mean, we had to go to a different location. There were like 30 of us in there, you know, and then since then numbers have definitely come down. So like I said, my pre-licensing class, there were 60, you know, so I go from 60 to 2. It's a big change. It's a big, big change. All right, real quick, I want to go through my exam expectations, then we'll take a break and then we'll get started. But again, I know you guys have taken exams before, but this is how I give my exam. So I need to make sure that we're all on the same page. While we are on break, you guys can go ahead and get the stuff that you need to take your test. As soon as we come back, I'm going to do a little check-in process with both of you. It won't take me long because there is only 2 of you. It's not like there's 60 of you. So I am going to do a little check-in process with both of you. I want to see your basic calculator. I can't let you use your phone, right? Because your phone has Google on it. So I do want to see your basic calculator. Your pen, pencil, purple crayon, I really don't care, some kind of writing utensil. I will allow you to have 2 blank pieces of scratch paper and 1 blank closing disclosure. So when we come back, I need to see your blank. I need to see that it's blank, front and back. I'll need to see blank. So you're going to show me that. I'll let you have drinks, snacks, cough drops, mints, gum, water, whatever. You guys, I'm going to want to see your real estate manual is near you. So I'm going to want you to show it to me. And then I want you to show putting it down over here or something. Why, you ask? Because I let you guys take bathroom breaks and I want to make sure this thing isn't in the bathroom. So I want to see that it's closed and near you. This isn't my first rodeo, Rodney, right? I also want to see that your phone is off. Are we good that off and silent are 2 different things? So I want you, and you guys go ahead and turn it off while you're gone, because it's amazing to me how many of us don't know how to turn our phone off. We don't do that. So you're going to hit a button and show me that it doesn't light up, right? That I can't see it and that it is off. On occasion, sometimes internet glitches, power goes out, right? Things happen. So right before the exam, I'm going to put my phone number in the chat. Once I check you guys in, I'll put my phone number in the chat. You will write my phone number on your blank piece of paper. So in the event that you lose power, you'll have my number right here. Turn your phone on and call me. I don't know what, if anything, can happen during the exam, but what I do know is we will get through it. Okay, we will get through it. It's happened. We probably got storms forming again this afternoon. So just want to let you guys know that I get it. I get it. And some things are out of our control. If at all possible, I'd like to show me your desk space too. So show me that you got like a nice clean, you know, desktop. I understand if you're on a desktop, you can't do that. So what you're going to have to do is hold your right hand up and say, Julie, I have nothing in my desk space that could count for cheating. We're going to have to go by the honor system here. Questions on that piece of it, the check-in. Okay. You guys are both good. I don't have to worry about this, but I don't allow virtual backgrounds or dimly lit spaces during the exam because I need to be able to see you. I'm going to watch you guys on Zoom. You guys are going to be watching your exam. So I need to be able to see you and make sure there's nobody behind you giving, you know, giving shouting answers out or anything. Also during break, if you guys will close down all tabs on your computer except Zoom, keep Zoom open. Close everything else down. So when the exam begins, you're only going to have 2 tabs open, Zoom, and then I will give you the link for Class Marker. You guys can minimize Zoom and you can kind of tuck it off to the side of your screen so you don't need to look at Zoom. I want you guys looking at the test. So you only have 2 tabs open once we start. Once the exam begins, I'm your only friend. Sorry. The only person you can communicate with is me. And the only way to communicate with me is via direct message. I cannot have you guys unmuting yourself and distracting each other. So if you have a question, if you need to leave your camera for any reason, have to go to the bathroom, got to get some more water, more scratch paper. If you're leaving your camera for any reason, you need to send me a direct message and let me know where you're going. Okay. Anything that comes up, never, ever, ever unmute yourself.
At the end of the exam, will we get our results we did in pre-licensing?
So, want to begin, I'll put the link in the chat, you click on it, you can begin or copy and paste, whichever. You get 3 hours. Passing is 75%, you get your results immediately. So Ronnie, once you hit submit, I think it says, are you sure? And you say yes or something similar to that. And you say, boom, pass or fail. You and I will both get an email with your results. So you can go back, we got them like categorized so you can see the main categories. I can't let you see pass or fail. I can't let you see the test questions, but you will get kind of a category, tell you how many questions on each topic that you missed so you can kind of know where to focus. But you will see your results immediately, yes. When you're done, you're done. You don't need to wait until 4:30, right? Once you're done and you've seen your results, you can log out of Zoom and go about your day and do your thing. Okay. When you click on the link for Class Marker and begin the exam, it's going to take you to something that looks like this. Please read this before you begin. This is saying that you're not going to cheat. You're not going to use text or visual images, phones, screenshots, anything like that. You guys are not to discuss this exam with other students. That would be considered cheating. This is a closed book exam. And then this last sentence, I think, is the most important. Anyone will receive a failing grade for the entire course. And I'm not going to deal with it. Lane's not going to deal with it. We're going to let you deal with it with the Real Estate Commission. So like I tell my pre-licensing is 60 people, don't give me reason to suspect you. The Real Estate Commission says if I suspect you of cheating, I'm supposed to take your exam away. So don't give me reason to question it. Again, I'm not worried about you 2 guys, but I am an equal opportunity person. So we have to go through the same thing that I do with the class of 60. It's only fair, yes? Once you begin your exam, you see 1 question per screen. You click next, you can go back if you want to. If you read a question and you're not sure the answer, I suggest bookmarking it. And then when you're done at the very end, every single page has a link on it that says see all questions. You can click on that link and it'll tell you which ones are answered, unanswered, or bookmarked. I highly recommend you click on see all questions before you submit and make sure every single one of those says answered. Okay, if you have anything unanswered or bookmarked, go back and get it. You're not going to get credit for it. You also have a little countdown clock on each screen. So keep like half an eye on it, just don't let time get away from you. If we're here, if you guys have like 10-15 minutes left, I will unmute myself just to ask you to watch your time, right? Because when the time is up, the time is up. And that's out of my control. That's Class Marker. So once Class Marker has been going for 3 hours, it kicks you out. So if you guys are still here, which I encourage you to take as much time as you would like, but I will just kind of give you a heads up that you're, 10-15 minutes before. When you pass, Lane will submit your course completion to the Real Estate Commission. She'll send you a certificate of completion. I don't know if you'll hear from Lane today. Lane's a pretty busy gal. So if you don't hear from her today, it'll probably be tomorrow. Just be patient with her. If you don't pass, you are eligible for a retake. So if you don't pass, probably the worst part of the retake is you got to spend some one-on-one time with me. So we'll get together and talk about, make sure, I want you guys to have an understanding of this stuff, not just for the retake, but for, you know, real life as well. And we'll schedule a date at that time if need be. And the rules for the retake are going to be the same. If I may offer some advice once we begin, always remember to breathe. Always remember to breathe. If you feel yourself, if you read a question, you say, oh my God, I've never seen this before in my entire life, stop. Take a few big deep breaths, get yourself centered. You're not going to do yourself any good when you're up here all crazy, right? Take a few big deep breaths and get yourself centered. Read. I need you to read the question and all the answer choices. Remember what we said at the beginning of class today. Every single word means something. So don't get to going through it too fast. If you feel like you're spending too much time on a problem, bookmark it and come back to it. So then you know how much time you have left. Every single one of us is guilty of this. Do not change an answer unless you are like 5,000% sure that it's wrong. Have you guys ever changed a right answer wrong before? I have. I know we have too. Stop it. Do not change an answer unless you are certain. I can't tell you how many times back in the day when I had to hand grade papers, tests, I can't tell you how many times I saw eraser marks from the right answer to the wrong answer. Stop it. And again, before you submit, just go back and make sure everything says answered. You don't get credit for an unanswered question. So just go back and make sure everything says answered. And then the last little piece of advice I have for you is to take your time, but watch your time. You get 3 hours. A lot of that is because of the math, but just take your time. Don't blow through it and then in 30 minutes, 45 minutes, and then wonder why you failed. Well, because you left 2+ hours on the table, right? Utilize your time. I know we want to get through this and go on, but utilize your time. Questions, comments? The last, which by the way, when the exam begins, your Zoom screen is going to look like this. I will not be sharing my screen. So your screen will look like this. And if you guys look at the top right, you have the little minimize, and you can minimize your Zoom. And like I said, just kind of tuck it off to the side. So you're not distracted by, I usually say others, but the other. I'll mute myself and turn my camera off. So I'll just be, I'll be here in the background watching. Okay. All right. Let's take our last break. By the way, one more thing. Also, after this class, Elaine will send a survey out. So it's anonymous. I mean, I could 50-50 guess who said what, but we do appreciate your feedback. It helps me grow. It helps the school grow. So we absolutely appreciate you taking the time and filling out that survey and letting us know what we can do to better improve the experience. So be on the lookout for that email from Lane as well. Okay. All right, let's take 10. We'll just go till 2. When we come back, we'll do a little check-in and we will get you guys started.